Okay, council, if I can have you both unmute. All right. Mr. O'Keefe, Mr. O'Keefe, are you appearing? Who are you appearing on behalf of
I'm sorry,
today?
for defendant Doug Trozak. I don't know whether my appearance made it in. I just got hired last week.
Okay, very good. Thank you. And then Mr. Dundon, you're appearing on behalf of Mr. Ingleson today?
Yes, Your Honor. Thank you.
Okay. All right, so we'll go on the record. This is Van Wormer versus Trozak. This is Emmet County file number 241085553. I'm sitting on this case by assignment. This was set today. Mr. Trozak, the defendant, had previously filed a motion to set aside a default. So this was set as a hearing on that. If I could just have both counsel put your appearances on.
Yes, good morning, Your Honor. Mark Dundon standing in on behalf of Harry Engelson for plaintiff.
Kurt O'Keefe on behalf of defendant Douglas Trozak.
Okay, thank you. Mr. O'Keefe, I guess I'll just address you first since it's Mr. Trozak's motion. How did you want to proceed today?
Well, Your Honor, I had requested an adjournment or if not a stipulation to set aside, but Mr. Engelson is out of the country. I did not get his answer till Friday. I drafted a supplemental affidavit for my client to file and FedEx to the court Friday, and I don't know whether that's in the court proceeding. Just very preliminarily, it appears from what I've seen that Mr. Engelson also did not appear at the last scheduling conference. So I'm not sure. I'm just getting into the case. Apparently, he was not defaulted, but the defendant was. Mr. Trozak, I'm frankly trying to get him into the 21st century. Apparently thinks that if he goes on a Zoom call, it will take all the tax return files off his computer. He also showed up at the wrong courthouse. He thought that physically being in the Emmet County courthouse would work, not realizing, of course, this court sits in Otsego County. So he was at the wrong courthouse in person, thinking that if he did that, he would not have to appear on Zoom. As far as a meritorious defense, I don't have the map, or I'd like to have the video of where this gas line was, but according to the supplemental affidavit, I emailed it to, well, I emailed it to Mr. Engelson. I'm sure Mr. Dundon does not have the gas line where it was capped by my client was totally in his property. It was not in the utility closet nor in the stairwell. So the court's opinion and order in the prior case said that plaintiff herein would have access to the utility room and the stairwell. The complaint indicates that this gas line was capped in the utility room, but that's not accurate. There's an exhibit to the supplemental affidavit, which is
Well,
attached.
and I don't want to cut you off, Mr. O'Keefe, but if do you want to adjourn the motion today?
That
Or
would
do you
be
want to,
fine. That would be fine
or
to
do
give me.
you,
Yes, Your Honor, that would be fine. I'm not here to. I'm here to give the court the information it wants. If I could have 2 weeks, I would file an amended motion to set aside the default and then have this all laid out for everyone ahead of time.
right, right. Okay. All right. Thank you. Mr. Dundon, what's your position on the request for
Your
the
Honor,
adjournment?
our position is that, and again, I appreciate the position Mr. O'Keefe's in, but this has been going on for quite a while, and Mr. Trozak never answered the complaint. He clearly had the complaint. He acknowledged it. He filed that, putting it politely, a rather bizarre case on his own, and he never answered. And we believe I didn't hear that this was in a separate room, but I believe implied in the court's 2018 order was clearly for him not to interfere with our client's gas line. And it sounds like there's no question that he shut off our client's utilities, Your Honor. And then our guy had I think it was almost 10 grand. I've got it all in here, Judge. So
Well,
I
well,
think
again, I don't want to, I cut off Mr. O'Keefe because I don't want to
yes,
sort
sir.
of have a hearing today. If we're going to have a
Yes,
hearing, we
sir.
need to have a hearing. And if we're not, we're not. I don't want to do it halfway. So it sounds like you're opposing the request for adjournment. Is that what I'm taking from you?
That's correct, Your Honor. Which again, I don't do neither Mr. Ingleson either does that lightly, and I generally don't want to sandbag another lawyer, but this has been going on for a good while. Thank you, Judge.
Okay. All right. The court is going to grant an adjournment. I think it's in the interest of justice and fairness to give Mr. O'Keefe an opportunity to file a proper supplement or motion to the extent he wants to, in light of Mr. Trozak's previous filing. Because Mr. O'Keefe has been recently retained, I think it's reasonable to give him an opportunity to get fully up to speed and file what he wants to file so that the court can make a proper ruling one way or the other on the request to set aside the default. Obviously, Mr. Dundon, your client, there's a preliminary injunction in place to protect your clients. I don't find that a short adjournment is going to result in any prejudice. I think given the proceedings so far and Mr. Trozak's failure to participate, again, I think having counsel be able to present his position here before the court so that the court can make a substantive ruling on the merits, I think is appropriate and really in everybody's best interest going forward, regardless of the ruling of the court. So I am going to grant the request for the adjournment. Mr. O'Keefe, I'm going to ask that you obtain a new hearing date and just ask the scheduling clerk to set aside an hour for the hearing and then send out notice of the date and time of that next hearing, which will be by Zoom pursuant to court rules. And then we'll go forward at that time. The only other correction I would indicate, Mr. O'Keefe, and again, I know you're just getting on the case, but there was a hearing that Mr. Ingleson didn't appear at. Your client also didn't appear. Nobody did. So I didn't issue any defaults arising out of that. And it wasn't until after that hearing, we had another hearing scheduled after that where neither of them appeared, at which time Mr. Ingleson did appear. And I believe the default came out of that hearing because your client did not appear.
Thank you, Your Honor. I have had a hard time figuring some of this out.
I can understand that. That's why I make sure the record is clear on that. Mr. O'Keefe, do you have any questions about what your side needs to do going forward to get this set for hearing?
No, Your Honor. I'll check with the scheduling clerk. I think I can have pleadings within 2 weeks, but I mean, counsel may want time to respond, and the court would have time to review. So I think we can set a date. I'll check with Mr. Ingleson. I think is back April 2nd, but I'll set up hearings per the court instruction. If there's an issue with that with Mr. Ingleson's office, I'm the new sheriff in town. I'll be happy to accommodate his schedule.
All right, thank you. Mr. Dundon, anything further for the record from your side?
No, Your Honor, we're good to go. Thank you. And I'll try to call Mr. O'Keefe and fill him in.
Okay. All right, very good. Thank you. That's all for this hearing today. All parties are free to disconnect at this time.
Thank you, Your Honor.
Okay, Mr. Spihar, are you able to hear me okay?
Yeah. There's just something in the.
All right, we'll go on the record now. This is People versus Kevin Spihar, case number 226450. The record should reflect Mr. Spihar is present today by video from the Otsego County Jail. We have Mr. Brunikel present, who is the supervising agent, and then Mr. Brown is here on behalf of Mr. Spihar for purposes of arraignment today. Mr. Spihar, you're before the court today for arraignment on an alleged technical probation violation. Do you understand why you're before the court?
Yes, sir.
Mr. Brown, have you had an opportunity to speak with Mr. Spihar at all today?
Yes, I have. Yes, I have, Judge.
Okay. All right. So, Mr. Spihar, a couple of things I need to go through with you. First of all, you do have the right to have a hearing as to whether or not you violated your probation as alleged. You also have the right to have a lawyer present at any subsequent proceedings. If you can't afford a lawyer, one will be appointed for you at public expense. If you are found guilty of violating your alleged probation in this case, because this would be a second technical violation, the maximum penalty that you could face would be up to 30 days in jail. Do you understand all those things that I've just stated to you?
Yes.
Okay. Mr. Brown, how does Mr. Spihar want to plead today to the alleged violation?
Your Honor, there is some information that he gave to me. At this point, I believe that we are going to set the matter for a contested hearing. That may change in the future once we get some more information, but that is how we want to proceed at this time. Okay,
so the court will enter a not guilty plea on behalf of Mr. Spihar. The court will set this for a hearing on its motion day in April. And regarding bond, pending that hearing, Mr. Brunikel, any position on probation on that?
Yeah, Mr. Spihar does not have stable residency and trouble making contact with probation. For those reasons, probation would recommend a substantial cash surety bond.
Thank you. Mr. Brown, anything on behalf of Mr. Spihar on bond?
Your Honor, Mr. Spihar does have some issues with communication. He is currently homeless. I believe that he may reside at least partially at a homeless shelter. It is my understanding he does not have any phone. He is very hard pressed and strapped here. Communication could be very difficult. He's also had various incarcerations in which communication may not have been feasible. So I would ask court to take all those things into consideration when setting a bond in this particular matter. I would also mention for the court that at 1 o'clock this afternoon, I do have some district court issues on 3 separate files, 1 felony and 2 misdemeanor files that he is going to be arraigned on for failing to appear. My guess is that it is likely due to his homelessness as well as not having any kind of phone or sufficient means of communication. I would just ask court to consider those things when setting a bond in this particular matter.
All right, thank you. The court finds that a cash bond would be appropriate for the reasons of ensuring Mr. Spihar's appearance at the next hearing. Although the maximum possible penalty here based on the technical violation is not substantial, the court finds for the reasons stated both by Mr. Brunikel and Mr. Brown that Mr. Spihar's continued appearance is an issue. And so the court's going to set bond in the amount of $5,000 cash or surety. The court finds that that is an amount and that would be sufficient to ensure his appearance. The court is also going to include as the conditions of that bond all the terms and conditions of his current probation. And then the court will set this for a hearing within the required 14-day time frame. Mr. Brunikel, anything else that we need to address today?
No, Your Honor.
Mr. Brown?
Just one thing, Your Honor. He does qualify for an attorney. That information has been sent to Mr. Gilo's office. Mr. Spihar, you should be given that information. Should you be able to bond out, you need to contact that attorney immediately.
Okay, Mr. Spehar, do you have any questions at all?
Without saying it.
Rather just, I don't know, I'd rather just plead guilty. I already get
Well,
30 days in Genesee County.
all right. Do you want to have a chance to talk to Mr. Brown privately before we conclude this hearing? I could put you in a breakout room with him.
Yeah.
Okay, hold on one second. Okay, Mr. Brown, did you have a chance to speak with Mr. Spehar about how he wants to proceed?
Yes, I have, Your Honor. At this time, I believe that he would like to enter a plea.
Okay, Mr. Spehar, did you have enough opportunity to speak with Mr. Brown about pleading guilty?
Yes, sir.
Is that how you want to go forward today?
Yes, sir.
Can you raise your right hand, please? You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You can lower your hand. Mr. Spehar, you understand that by pleading guilty, you're going to be giving up the right to have a hearing as to whether or not you did violate your probation?
Yes.
And then again, as I indicated, the maximum penalty you could face by pleading guilty would be up to 30 days in jail. Do you understand that?
I do.
With that in mind, what is your plea to the alleged violation today?
Guilty.
Has anybody threatened you with anything to get you to plead guilty?
No.
Has anyone promised you anything other than what we've talked about here in court today?
They have not.
Is it your own free choice to enter this plea?
Yes, Your Honor, it is.
Are you pleading guilty because you did violate your probation?
Yes.
So on or about February 19th, middle of February of 2025, were you on probation out of Otsego County?
Yes, I was.
Were you aware that one of the conditions of your probation was that you were to report to your probation agent as directed?
Yes, but I didn't know what the date was.
Okay. Did you make any attempts to contact your probation agent to find out when you were supposed to report?
I did not. I just did it the first time when I got out last time in jail. Understand what I'm saying?
So when you were released, you checked in with probation, but then you didn't check in again or find out when you needed to check in. Is that correct?
Yes.
Okay. All right. The court finds that the plea is knowing, voluntary, and accurate. The court is satisfied, based on Mr. Speaker's testimony, that there is an adequate factual basis to support a finding that he did violate his probation by failing to report to his agent following his release from jail in the initial contact. The court will accept the guilty plea. Mr. Brunical, do you have any recommendations for sentencing?
Yes, Your Honor. Given it's his second technical probation violation, the recommendation is 30 days jail with 2 days credit for time served.
Thank you. Mr. Brown, anything on behalf of Mr. Spehar?
Your Honor, I would just state that Mr. Spehar has been in the Genesee County Jail. He, I believe, did about 30 days at the Genesee County Jail as well on a similar probation violation here. I don't necessarily believe that the court is obligated to give him credit for any of that time served. However, I would ask the court to take it into consideration. Mr. Spehar has a lot going on. And it is not uncommon for people who have multiple court cases in multiple counties to lose track of certain things. I don't necessarily think there's any evidence that it was willful, but it could just potentially be a fact that he failed to do it simply because he had so many other things going on. I would ask the court to take that into consideration.
I turned myself in.
Yeah, Mr. Spehar, is there anything that you wanted to say?
I turned myself in Genesee County for both these probation violations, or the probation violations here and there.
Okay. All right. I did have a chance to review the file during the break here. So the court's familiar with the underlying facts as well as generally Mr. Spehar's term of probation. It looks like he was placed on probation back on October 25th. In this case, there was one previous violation of probation in January that resulted in a guilty plea, and Mr. Spehar was sentenced to 15 days in jail as that was a first technical probation violation. Here we are. Really, this one took place less than a month after the previous one. So the court finds that there has been issues with Mr. Spihar's compliance. There very well may be reasons why, including housing insecurity and other issues, as well as Mr. Spihar's other cases in different jurisdictions. But that's one of the difficulties of having multiple convictions and being on probation jurisdictions is it places a lot of obligation on the defendant to make sure he knows where he's supposed to be and when, and make arrangements for that. Or at the very least to contact the agent and say, look, I can't make it, I've got issues. Typically, I think agents are willing to work with individuals, some contact, which I find that there isn't any evidence of here. So the court finds that generally progressive discipline is appropriate. As the violations continue, the penalties and consequences get more severe. And in this case, the court finds that a 30-day sentence is warranted. So the court will sentence Mr. Spihar to 30 days in the Otsego County Jail with credit for 2 days served. And continue Mr. Spihar on probation. Mr. Spihar, you do have the ability to seek an appeal of this sentence. The court will provide you with some paperwork at the jail outlining what your appellate rights are, as well as how to request a court-appointed attorney to help you with any appeal. Mr. Brunical, will you check in with Mr. Spihar prior to his release?
Yes, Your Honor.
Okay, so Mr. Spihar, make sure that you follow the direction of Mr. Brunical once you are released from Otsego County Jail. Mr. Brunical, anything else that we need to address for the record today?
Nothing today, thank you.
Mr. Brown?
No, Your Honor, thank you.
Okay. All right, that's all for this hearing today. All parties are free to disconnect at this time.
Thank you.